Excellency, the President of the Assembly of States Parties, Your Excellencies, distinguished participants. I have the unusual opportunity, on behalf of the ICCBA, to address you for a second time as President. Indeed, this may be a unique event, as ordinarily the presidential term is 1 year only. But in these strange times, unusual things happen. And so, in the interest of continuity, the association has re-elected me. I'm sad that I cannot be there in person. Last year, when I stood before you at the World Forum, I advanced the case of the ICCBA being recognised as a representative organisation of counsel and other lawyers who use the court. That call was answered by the passing of a resolution to that effect. The association thus began this year with high hopes that it would truly be a contributor to the development of the court's operations, a partner even, that it would have a seat at the table in any matters relevant to its membership. And what is its membership? Frankly, I tire of reminding people that the ICCBA is not some trade union of defence lawyers. Its membership embraces those who represent accused persons and victims, as well as states, amicus curiae, and other interested parties. And when I say represent, I don't just mean counsel. The junior staff within those teams are also within its membership. The ICCBA is thus a major stakeholder in the process of the court's management, because it represents a significant proportion of those who use the court. And that means so much more than just going into the courtroom. Its members use the ICC building. They go on missions. They visit the detention unit. And they are subject to the court's regulations, its codes of conduct, and its legal aid policy. As a resource, the ICCBA is a precious and priceless one. It offers a wealth of direct experience of so many areas of the court's operations, and where and how they might be improved. To ignore that resource would be folly, but more than that, it would undermine the court's credibility in the eyes not just of those who represent accused, but also those who champion victims' rights. Plainly, the states parties, in passing last year's resolution, envisaged a more significant role for the ICCBA within the court's framework, and that process was made concrete during the review process, when the panels of experts fully engaged with the association and reflected its views in a number of the recommendations. Of course, there was not really much going on at the court this year, so it is perhaps not entirely fair to judge the extent to which the changed status of the ICCBA has been reflected in the attitude of the court's major organs towards it. Certainly, there has been collaboration on training, outreach, and a coordinated approach towards the taxation of independent counsel by the Dutch authorities. Nonetheless, it was disappointing that the association was not invited to join the COVID response group, and several other items of business, which might readily have advanced notwithstanding the pandemic, have lain dormant for most of the year. The proof of the pudding will be in the eating, and it will probably be my successor who has the honour of reporting on issues of major importance, such as the revised legal aid policy and the resolution of the issue of taxation by the Dutch. But I would hope that the states parties would see the value and importance of the ICCBA having a seat at the table in relation to the issues which directly affect its membership, and that will include not just legal aid and taxation, but also the implementation of the experts' recommendations in review. Elsewhere, the ICCBA continues to reach out to and form associations with bars around the world. to offer training and support to its membership, and to collaborate with the prosecution and the registry on new protocols and practices for court users. As I said at the opening of the legal year, the ICCBA is committed to the court's objectives and remains a willing and enthusiastic partner in achieving them. Thank you very much.